Justice Sikri, ladies and gentlemen, it's a privilege to address you and to address you on a topic on which I was given some freedom of choice. And so I have decided to talk for a short while about the future of legal practice as I see it. We must not forget that one of the fundamentals, in fact, perhaps the column of a strong free economy, is a robust legal system that delivers justice. And I think we can be legitimately proud of the system that we have built up so far. Our judges, who are innovative, independent in thought, courageous, our lawyers, lakhs of whom have tremendous experience, and all other stakeholders in the system. But like all established systems, there is always need for change. In fact, change should be a constant imperative. And so I'm going to talk to you today about where I think our legal system, particularly in the context of commercial litigation, should go in the future. We have all had time to reflect over the last year and a half on how we practice and what we practice. And I do believe that the practice of law internationally, and certainly in our country, has changed forever. There are, of course, certain constants. There is going to be increasingly in the future a lack of time, a lack of judges, a lack of capital investment, and a huge burden in terms of commercial litigation that will tax the system. It would tax any system, and it certainly will tax our system. But the time has come for us as individual lawyers and as individual stakeholders, I believe, to pick ourselves up, dust ourselves off, and move ahead. Enough of blaming other interests, enough of blaming the government, enough of blaming the court system. We now as lawyers have to do it ourselves. We have to change ourselves. We have the hardware in place as far as commercial litigation is concerned in India. We have not only a very forward-looking Arbitration Act, which was rejuvenated by amendments in 2015, but we have the Commercial Courts Act, which is one of the most forward-looking acts of commercial dispute resolution in the world. We have significant amendments to the Specific Relief Act, which now respects the sanctity of contract and takes away a large part of the discretion in not awarding specific performance of contracts. So we have the hardware, as it were, in place. But I think what we now need to see is a change in mindset and approach of lawyers. And I say so with all humility, taking upon myself also equal responsibility for the manner in which some parts of our practice have progressed. I think there is need for a change in approach in broadly 4 areas. First area is to understand that longer is not better. Shorter arguments, shorter pleadings, shorter submissions are better, but they are, of course, that much more difficult for a lawyer. I remember the great French philosopher Blaise Pascal had once apologized to a friend to whom he wrote a 15 or 20-page letter. And he said that, "I'm sorry I wrote you such a long letter. I didn't have the time to write a shorter one." And any lawyer will tell you that it's far more difficult to make a 10-page submission or a 5-page submission than it is to make a 50-pager. But I think longer is now no longer better. We have to think more concisely. We have to put our thoughts down far more concisely. That's the first change of approach. The second is courts have been too indulgent in giving us endless time for oral arguments and submissions. The time has come now to shift the emphasis to written submissions and to restrict oral arguments. The third is the approach all of us have of trying to ambush our opponent. We always want to take him by surprise. We don't want to disclose the authorities we're going to cite. We don't want to disclose our argument up to the last possible moment. And all of us know that in 9 cases out of 10, it really doesn't make a difference. Perhaps in 10 out of 10, it doesn't make a difference, because gone are the days when a court would not grant you a little time to consider your opponent's argument or judgments. They will always give you overnight. So there is no advantage now gained in ambushing, but we still, all of us, resort to it. And the fourth change in approach is that for breach of any of the above, courts must now start awarding realistic costs, because commercial litigation and lawyers, as we know, are not cheap. It costs a lot of money to have adjournments. It costs money which ultimately is taxed into the system and therefore causes a loss to the economy and the system as a whole. So I envision 4 game changers. I'm not saying these are the only 4, there'll be many other suggestions, but I think at least 4 game changers to rejuvenate and make more lean our justice delivery system as far as commercial litigation is concerned. And this would largely apply to a final hearing, not to a shorter interim hearing. One is, the time has come, as the Supreme Court also has said, to have some page limits on pleadings and a readily accessible format for pleadings. Simplicity, a list of dates, submissions, prayers, no repetition, and no verbose 50, 100-page pleadings. It's not necessary. It detracts from the issue at hand. We could even advance further, as some jurisdictions do, and encourage citation of legal authorities in the pleadings themselves, so the other side is put to notice of exactly what you're going to cite. The second is a detailed written submission to be filed in advance of the actual oral hearing. And when I say detailed, I don't mean a 100-pager. I mean a 20-pager, a 30-pager, in some cases even a 50-pager. But a submission that encapsulates your entire case and the answers to your opponent's case all in one, so the judge only has to read that. He doesn't have to go into the morass of pleadings and documents to understand the respective cases. Filing these submissions in advance of the hearing is of inestimable value, and I'll tell you why. Any lawyer will tell you that when you have to put your thoughts down on paper, actually see them in black and white, you start jettisoning many of the arguments which you might easily have made had it been a purely or oral argument, because you know it can't be sustained. So it focuses your own argument and thought. It gives the other side notice of what you're going to argue. So if they have any answer, they can orally argue that. And I say orally because I would commend an exchange of written submissions in advance, not sequential, because if they are sequential and the petitioner first files his submissions, the respondent then files counter submissions, and then it's a never-ending game. It must be simultaneous. The third game changer would be, in longer, heavier matters, some time estimates to be given by counsel and to be imposed by the court. I don't even mean strict time limits. Our system should not have the strict time limits, say, of the US Supreme Court, where in the heaviest of constitutional matters, you have to file your written brief in advance that is fully analyzed and digested by the judges and their law clerks, so that when you actually come to court, it's a half-an-hour hearing. And half an hour means half an hour. At 28 minutes, a green light comes on, at which point the lawyer is permitted to complete the issue or the thought that he is on. And at 30 minutes, a red light comes on, at which point the lawyer is permitted to complete the sentence. And mind you, in those 30 minutes, the judges ask a lot of questions, so the 30 minutes are not entirely yours. That system would not work in India, and I don't think it's the way to go for complex commercial litigation. But there are systems in other forms of dispute resolution, such as, for example, international arbitration, where you have a chess clock system, where a certain number of hours is allotted to the matter. And that is equally divided between the two sides. And you can carve up or use your part of the time as you wish, but you are restricted to your time. And when you come to the end, and the time is counted in terms of minutes, not in terms of even half hours, you are held to your estimate. And even to go 5 minutes over time, you have to seek the leave of the court or the arbitrators to do so. I remember once reading a poll having been conducted amongst leading international arbitrators. And they were asked, what are the three things you like most about counsel? And what are the three things you like least? On top of the list of what they liked most was counsel who stuck to their time limits. And on top of the list of what they liked least was counsel who exceeded their time limits. And this was a poll of several leading arbitrators, not insignificant people with great experience. So that's the third area, some element of being conscious that time is a very precious commodity and an expensive commodity in our legal system. We can't afford to waste it. And within that time estimate must also come the sanctity of dates that are given in court. Lawyers must not, as far as possible, try to take briefs that might conflict. They must be ready to go on. An application for adjournments must be kept to a minimum. All of us are guilty of this. I don't exclude myself, but I think the time has now come for all of us to collectively change as a bar and as lawyers. We owe it to the system. The fourth game-changing area will be imposition of more realistic costs by courts. In our system, we find that it is possible to mount any application, file any petition, however frivolous, however time-consuming, however unmeritorious. And when you lose, there is really no consequence to losing. The highest consequence often is an admonition in the judgment, but there is no consequence in terms of costs or expense. So a recalcitrant litigant is encouraged to file one application after another to delay the final hearing, and any litigant finds that filing speculative applications does not cost him or her anything. That has to stop as far as commercial litigation is concerned. I'm not suggesting that costs should be imposed regardless of the financial capacity of the party on whom they are imposed. Obviously, a court will take that into account. But when you have big corporate litigants, even powerful and rich individuals who use the legal system to fight their battles, a degree of responsibility and accountability is called for. And that includes not filing applications which are frivolous, applications which are known to be unmeritorious, but which are filed only to lengthen and delay the proceedings or to divert them from the real issue at hand. And therefore, a judicious imposition of actual costs will have the immediate effect of drying up a lot of this, what we call luxury litigation, and will keep the system clear for more time and give it more time to decide the matters that are required to be decided urgently. These are the four game changers I would suggest. They won't cost anything more to introduce, but the bar has to cooperate, and all of us lawyers have to cooperate. And I would strongly recommend that this be done starting from the large law firms by taking an open and written pledge that these are the principles of conduct that we will adhere to when we conduct commercial litigation, whether in courts or in arbitration. And each individual lawyer must, herself or himself, adopt such a code of conduct, regardless of whether the opponent does so or not. We have to become the change we want to see. That was what Gandhiji had told us, and I think it's so true even in our current legal system. One of the key advantages that I believe India scores over China on is the vibrancy and accessibility of our courts and legal system. We have a common law system that goes back to at least 160 or 170 years when the chartered high courts were established, and even longer if you take the other courts into account. From the time the chartered courts high courts were established, they were courts of record. So you have recorded judgments and orders from 1860, 1862, right to the present. This is a huge fund and a lot of it is commercial law. We have a vast body of talented lawyers, including lawyers not only in the big cities, but in the smaller towns, who are possibly far more adept at evidence and trial actions than lawyers are practicing in the high courts. We have a vast body of skilled infrastructure staff who can be trained we have excellent stenographers, we can train them to be real-time transcribers and really up the ante in terms of introducing technology in the way we practice law. All this is available to us. All we have to do is now start. And as I said, the start has to be unilateral. If you're going to wait for your opponent to do it, it's never going to happen. So where do I think we go to from here? We have had and we are continuing to have a pandemic, which is a crisis. But as was once said, never let a crisis go to waste. I think all of us have learnt now in small measure something about the technology of how we practice. We've learned how to curtail our arguments, stick within time limits, and we have understood and accepted that there cannot be unlimited oral hearings. Virtual hearings, I believe, are here to stay. They have the advantage of efficiency, they are cost efficacious, easier for litigants, they are time saving. And for several applications, I believe virtual hearings should be the rule rather than the exception. Even for more complex hearings, virtual hearings, I believe, can and must be the path forward. Virtual hearings make our bar an all-India bar because you can practice in any court. And that is a good thing because courts must get the advantage and the benefit of lawyers from all over the country. E-filings, a new etiquette of how to conduct matters, all this, I believe, will come in the months and years to come. And if there's a problem about weak internet, go out and get better internet is the solution. No one can say that India, one of the leaders and vanguards in information technology, cannot get good internets for its courts, tribunals, and arbitration forums. So I end by saying, treat this as an opportunity. The future is ours to shape. Go out, improve yourselves, embrace technology, and get the fundamentals right. Because if you get the fundamentals right, it's always better for the litigant and it's better for the system as a whole, which all of us lawyers are here to serve. Thank you very much for listening patiently.